Well, let's talk about the study. I mean, there's another case, but we do whatever we want. It's your
Yeah,
show.
the study, and we both have we have other podcasts we got to do in a few minutes and 20 minutes, but that came out where it said if you are going to federal litigation, appeals, immigration space, if you are going with a big law firm that's doing like a pro bono, a small law firm, the chances of success are like extraordinarily higher if you have a big firm handling as opposed to a small firm, which obviously could be very offensive to the mass majority of immigration law firms that are considered small law firms. And so, have you heard about that? I just read some AILA commentary in the listserv. I didn't get too much into it, but have you heard of this study or these comments?
I'm sorry, I got to ask you to repeat it just a bit. Was it that if you're in a big firm, you have a better chance of winning in federal litigation than if you're in a small firm?
Yeah, they did they say significantly better if you have the resources of a big firm. The chance of success is much like extraordinarily greater than if you get like an immigration law firm.
And this is in federal court, not immigration court?
Federal appeals court. One of the arguments was that these big law firms have more federal experience than smaller firms, so they can handle it. Plus, they have the staffing to be able to handle like the amount of paperwork and all that stuff that's involved.
Yeah, that's not surprising at all. I think I have seen this. I mean, when we brought our TPS litigation against the Trump administration, um, for ending TPS for Haitians after Trump said all Haitians have AIDS and why do we need more Haitians and blah 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 blah. We brought that with Mayor Brown, the big law firm. We did it for a reason. I mean, the amount of manpower, the amount of the discovery was something like 65,000 pages, and we had like 6 weeks of discovery during Christmas in 2019 or something like that. Like it would have been impossible for our firm to do it. Not to mention, and it's public. I won't get into the numbers specifically, but that litigation cost
Oh, wow.
millions of dollars, and that was before it even got appealed to the Second Circuit. A small firm can't afford millions of dollars. I mean, for the trial alone in the Eastern District of New York, Mayor Brown graciously rented out half of the floor of a hotel in Brooklyn. So and they brought in printers, and I mean they had a whole war room. So that's what's required of federal court. I think it's kind of tragic, and it's an extension of this, the fact that immigration practitioners don't really do their own Supreme Court litigation anymore.
Yeah.
And we, worked with Wilmer Hale on the Patel litigation, for example, before the Supreme Court, because so much goes into it that if you don't have the resources, it could really bankrupt you. I mean, again, public knowledge. I think Mayor Brown had a gross profit last year of $1 billion.
Yeah.
So it's just different worlds. So it's not surprising if you're throwing 5 or 6 really smart people at something, it's going to have a better result than one,
Yeah.
which
And
is too bad.
there's an aspect that they'll be more picky on the cases they do,
That
whereas
too.
smaller firms might just, a lot of stuff's Hail Mary kind of stuff we're throwing out there. I mean, they're not going to just pick any case. Like, okay, this one, they have probably a board that analyzes these cases, makes decisions on things that are worth the shot, worth the time. So, but yeah, it's an interesting phenomenon, and it is what it is. Yeah, it's